Okay, now we're live. Hey, it's Tyler Flood, Houston, Texas DWI defense attorney, coming to you live from Bourbon Street in New Orleans at Mastering Scientific Seminar, the annual seminar put on by TCDLA and the National College for DUI Defense. And I'm here with my two associates, James Fletcher and Justin Harris.
Hey guys.
And they are here to help ask questions in case nobody would know anything about DWI. We're sitting out in the courtyard, and it's a nice day, and we are just waiting for questions. But I can tell you a little bit right now. Justin's actually taking a picture of me doing this because he thinks it's kind of strange. But so what about DWI, and why do you
It's good, right?
Why do you defend drunk drivers? That's what this felony judge in Orange County asked me the other day, and so he said, so you just like getting drunks off the street? And my response was, I'm more interested in the law and the law being followed. And this was a case where there's a warrantless blood draw, which falls under the McNeely case. And the judge he denied a motion to suppress the blood. And he's reconsidering because he's watching the PDRs going up. But eventually he's going to have to suppress the blood, and it might save this person a lot of time in federal or in TDC. If we can get him off of a felony, if the case gets reduced and the blood is out, I think.
Why is
that's my
a
opinion.
big deal?
Let me see if this chat is working. I'm chatting. Anybody see any of the chat?
I still can't get on that.
Is there anybody there? Anybody out there? Shelly, are you there? Can you chat with me?
She texted you.
Yeah. Text her back
Tell her
for
I
me.
can't get on. I don't
So
know.
McNeely versus Missouri was a Supreme Court case that said that you have to have a warrant basically to draw somebody's blood now across all the 50 states. There are certain state statutes that allow for exceptions to the warrant requirement. Like if it was a third offense, you did not have to have a warrant to draw somebody's blood. If you cause serious bodily injury to someone, you did not have to get a warrant to draw somebody's blood. There were other exceptions to so it was an end run around the Fourth Amendment of the United States Constitution. You could draw somebody's blood without a warrant. And the Supreme Court stepped in, and it was a landmark decision. And they said there is no valid exception to a warrantless blood draw, search of the person's body, sticking a needle into their arm, drawing their blood, except for if there are such circumstances that the time is such a factor that you cannot get a warrant in time. And the alcohol so it's exigent circumstances is the exception. But just the dissipation of alcohol from the person's body, like the elimination and the lowering BAC, is not a reason to draw a person's blood without a warrant any longer. And this changed the face of DWI work in Texas and around the country. It was a big decision, and everything has changed since then. Houston, though, they just started doing warrants across the board as soon as that came out, but there are still other counties that will do warrantless blood draws, thinking they can get away with it under the statutory exceptions to the warrant, but that's coming to an end.
And that's what this judge is asking about, right?
Yeah, so this judge, he's a smart judge, and I have a lot of respect for him. And he's interested in seeing, so a lot of these cases from other counties are on appeal, and he's waiting to see how they come out. He's been waiting on have come out in favor of McNeely, upholding exactly what it says, that you have to have a warrant. And he took our case off the trial docket, and it's kind of just hanging out there, and it's indefinitely pending right now. And I think that's because, and I would do the same thing if I was the judge too. I don't want to be reversed. He's waiting to see how some of these other decisions come out, but they're all coming out consistent with McNeely. So Where's all my people with the questions? I'm trying to chat. Maybe I need to invite.
She says it keeps freezing on her end.
Oh,
There's also
no.
an option for Q&A that I don't see.
Yeah, I see that.
No chat. It is recording, so it will be available later too.
Ask your audience to submit questions, and they will appear below.
Get on this
I see the Q&A, and I've enabled it.
Hey, I was doing a chat, but yeah, but like
I'm chatting.
like I'm on this one, right? The Google Plus page, but there's no like I already submitted that I would do it, but it doesn't give me a chance to. Wait, oh, here we go. Let's do that. Buffering. Google Plus Hangouts.
Okay, I'm inviting Shelly Fagan. What's that?
So I can hear myself and you on a 2-minute delay.
That's good. So you guys have a Google Plus account, right?
Yeah. But I mean, I get to your page and like, you were here, right? And then it just kind of started. I already RSVP'd and everything. Maybe. Have to put on your calendar.
Tell Shelly that I just invited her. My marketing manager is Shelly Fagan, who helped set up this brilliant idea for today, Friday, the premiere. Bear with us.
That sounds great.
Live from Bourbon Street, 2 p.m. This is going to be a weekly event. So the reason that I decided to do this, it's not for marketing purposes. Justin Harris, who is right here, and there's James.
Hey.
Justin came to me the other day and said, Tyler, I've got a lot of friends that are my contemporaries, and they have questions about their DWI cases, and they'd love to get 15 minutes of your time just to ask you specifics about their case. And I am always willing to help teach. And I had no mentor when I was starting out in criminal defense, and it would have been much easier and nicer to have someone telling me all the answers, so I didn't learn by trial and error. And there was a couple people that were pioneers in this field, but they weren't real interested in sharing their knowledge with younger attorneys. They acted like they were, and they said they were, and they would speak at seminars, but they didn't really share anything that was worth much to the younger lawyers. So I had to figure it out all on my own. There's a lot of competition in getting clients that are charged with DWI, and I understand that. That's completely separate, and I draw a line between what we do in court and getting clients. So we're all competing to get the business, but once you get the business, and if it's not me that's getting the business, I still want to arm everybody to go be able to kick the prosecutor's ass in court. And I want to arm people with the knowledge for them to be able to succeed in court. And I think that's only fair. Some people say, don't tell all your secrets. My paralegal, Andrea, sometimes says that. I don't tell all of our secrets. I tell people to work hard, be ethical, and research the hell out of your case, do a thorough investigation. And I can tell another attorney every single thing that we do on a DWI case. And then it's up to that attorney to actually do it. 99% of the people that I tell what to do who have come to my office and said, hey, can I go over this file with you? And we tell them, okay, here's what you need to do. Then they go back to their office and they don't do any of it. So there's not much of a risk in arming people with the education of what to do, because most lawyers are just very lazy and they don't do the right thing. So I'm doing this because I want to share my knowledge with other attorneys And if there are questions to be asked about a specific case, then we want to talk about that. But so Shelly, it looks like Shelly just joined. Great. Now maybe she can chat. Some people, oh my gosh, they have a question for me. Anybody?
I don't know if I ask a question.
Type faster. I'm just kidding.
That's still not join.
I can see you. I just don't know how to ask you.
Please bear with us next week on Friday at 2 o'clock. We will have the kinks worked out, and this is going to be a weekly, very valuable. It's completely free DWI advice, okay? And just a forum for you to ask questions. Anything you want about a case specifically, I will be happy to answer and tell you what I think. I've tried over 130 jury trials, so I've seen a thing or two, and we can talk strategy about any specifics. I'll tell you one thing. There's a question out there right now. There's an attorney going around saying, you know what? So a long time ago, we got the domain donotblow.com. They did not used to draw blood if you refused a breath test. So if you refused, there was no BAC level. In those cases, the percentage of winning much higher. Now do not blow needs to be explained a little bit. The best answer is, do you blow or do you don't blow? The worst advice you can probably get or hear from any attorney is just go ahead and blow and give evidence against yourself. That does not make any sense at all. And all of my contemporaries and my colleagues and my peers agree that that's bad advice, because you are effectively saying give freely all the evidence that you can against yourself. It's like saying go ahead and take all the sobriety tests. Tell the officer where you were. Tell him everything that you had to drink. Why not just go ahead and do that? Don't just blow. That's not good advice. If you refuse to blow, there are many counties in Texas that will not draw your blood. It's a pretty difficult process to go through to get a blood draw. You have to write a probable cause affidavit, present it to a magistrate. They have to issue a warrant and draw the blood. They have to have a phlebotomist on hand, follow proper blood draw procedures. There are so many humans involved in the blood draw process, from the draw to the testing, that it's much more easy. It's much easier to attack a blood draw than a breath test. All right, we got our first question. So definitely don't ever tell anybody that it's okay to just blow. That's terrible advice. We won 14 blood draw cases last year. We've already won 5 blood draw cases this year alone. We had so the first question is, what is the disconnect defense? That's a good question, because that comes into play with the case we tried last week. We had a client charged with a second DWI offense, and so the plea bargain was 2 years probation and 3 days in jail as a condition, because it's required on a second offense if it's outside of 5 years. That wasn't a good plea bargain. We didn't want to plead guilty and take another conviction. Would have been a second DWI conviction. If we went to trial and we lost, we knew that we would receive the exact same punishment, maybe a couple $100 more of a fine. It would be 2 years probation with 3 days in jail, so there's no risk of going to trial. I woke up the morning of trial, which this happened to be just yesterday, and after scouring the 2 binders full of documents we've compiled for this case, and I told my paralegal, who is one of the 9 board-certified paralegals in the state of Texas, and now I was on the committee to help grade the exams, Andrea Podlesny. I said, Andrea, I don't know how I'm going to win this case today. And I met with my client, and I asked him again, tell me the story about, tell me what you would say if you're under oath. I had already talked to him about this before, but I just wanted to see if he was still solid on those answers. If they ask you how many drinks you had, what would you say? He said, it was 3 drinks, Tyler. I went to dinner with my girlfriend because she got a new job, and she had 3 drinks as well. I lied to the cop. I told him 1 drink. I lied to the cop. I told him I was at a friend's house. But at the scene, the officers released the truck to the girlfriend without any suspicion that she was intoxicated at all. I said, look, if that's the true story, the jury needs to hear that from you, because you have a .15 blood test 2 hours later, and they're going to walk that back up to much higher. So the video looked so good, disconnect defense matches up. If there's a video of a person falling over, they look intoxicated, they are stumbling, their speech is very slurred, you can tell by the video that they're drunk. And then you have a high BAC. That evidence matches each other. It supports itself. And so it's connected, right? If there's a high BAC and you have a person who performs very well on the field sobriety test, you're going to fail those technically anyway. If you miss touching your heel to toe 1 time out of 18 steps by ½ an inch, they're going to count that as a clue of intoxication. It only takes 2 out of 8 for you to fail the walk and turn. So you have a person that looks good on video and a high BAC. So that evidence doesn't match up. So that's called disconnect. It's disconnected. The evidence is not connected. It doesn't match up. It doesn't support itself. And you draw a line through that with the jury in their mind and physically with your hand when you're talking to them. And you say, look, we might not know what the problem is with this BAC, this blood test, but there's obviously a problem. It doesn't match what, and I'll take out a thermometer and I'll hold it up and I'll say, what if you see your son or 103, and you look at them and you ask them, how do you feel? And they say, I feel fine. I don't feel, and you feel their head. They have no fever. They're no symptoms of being sick. What do you think the problem is? There's something wrong with that thermometer, but it's wrong. What if you test like 88? That doesn't support the way they look either. So that's it's not know exactly what the problem is with that blood test, but you know that there is a problem. We got a not guilty. We went through all of the human error possibilities. Police that handled it, was at the lab who prepared the vials for testing, and chromatography is probably reliable. You tested that blood, it gave a reliable result. But all the human involvement before it reaches you can be a source of many errors. And so the jury said, you're absolutely right, the evidence is disconnected. We don't know what's wrong with that BAC, why it's so high. They said he would have been at .21 at the time of driving, and we showed that would have been 16 to 18 beers. So my client testified, and he told the good story, and he owned up to the lies. He said it was nervous. It probably wasn't the best thing to tell at a friend's house, but the truth was we believed him, and they found him not guilty. They said there was no way that BAC level matches up with that. Okay, we have another question right here. Defend a high same as a low blood test. Well, a lot of lawyers probably would say, how do you defend a blood test? Two distinct strand blood tests based on the BAC level. Ideally, you want like a .08 or a .09. Because the prosecutor has to prove what your BAC was at the time you were driving, not at the time you were tested. And judges will re-emphasize that. So if you're arrested and you're tested, the test is usually an hour or 2 later. Well, the charge is driving while intoxicated. So if you're a .08 or .09 2 hours after you were driving, that's not the number that can be considered when a jury is deciding whether to convict or not. It takes an expert from the state to say, okay, based on this information that I obtained, I can go back and do a retrograde extrapolation and tell you what the BAC level was at the time of driving, which would have been driving while intoxicated. If you're a 0.08 or 0.09, them to prove that you were above a 0.08 at the time of driving. They have to have certain factors, and we'll go into that probably another time, but they at least need to know the time of your last drink, because people are either absorbing, going up. When you drink, your alcohol level goes up, and then eventually you peak, and then you start eliminating and you go down. If they don't know the time you had your last drink, they don't know if you're still rising when when they pulled you over, if you're eliminating. And if they don't know that, they can't predict what your BAC was at the time of driving. So for a low BAC, that's the strategy we use. Most of the time in doing this, I just told the client that we won at trial a month ago that I had never had the state ever try a 0.08 or 0.09 case against me ever. Well, they went to trial against us on a 0.09, and we got a not guilty. It was pretty easy. They could not extrapolate, and the jury didn't believe that the person was a 0.08 at the time of driving. So if you have a high BAC now, that's where you use the disconnect defense, if there's a video that looks good. If you have a video where you look at it and technically they failed the sobriety test, not really that concerned about that, because a jury, I always try to put myself in the jury's shoes. They just want to see overall, how does that person's balance look? Do they look like an intoxicated person? They don't really care that much about what the officer says. Well, they didn't turn using a series of small steps. They missed touching heel to toe by a half an inch. They pulled their arm 6 inches away from their body. The jury can tell if a person is intoxicated or not, telling them about the technical clues. So if you have a decent video, it doesn't even have to be perfect, and a high BAC, then you just say what we do there, which is really fun, and I did it with this last trial yesterday. I can't believe it, or yesterday. I ask the jury in voir dire, and I pull out my flip chart. I say, let's talk about what you think people look like at a 0.02, and then a 0.04, and then say a 0.08. What do you think a person looks like at a 0.08 who's legally intoxicated? And they'll tell me signs of intoxication. And then you walk it up to a 0.12, and then a 0.14. And by a 0.14, this jury said vomiting, blackout, unconscious. I left it alone at that. That's what I wrote down on the paper, and I knew that the 0.15 was our BAC, so anything higher than 0.14, they'd have to be much worse. And I also knew that we could make the BAC higher at a 0.21, and there's no way a jury would think that the way this person looked on video, they were a 0.21. That's ridiculous. And so on in closing arguments, we bring out the pad again, and we show them, here's what you said you thought a person would look like at a 0.14, blackout. We have a person here who's not blacked out, and they're saying that he had 16 to 18 beers. This is where I told you this evidence is disconnected. I said, picture what it would look like to have 16 to 18 beers stacked up in front of you on this jury rail right here. And it was a 10-minute not guilty verdict. So there's different strategies for a low BAC versus a high BAC. It's kind of funny because you either want a really low BAC or you want a really super high BAC. You don't really want one that's like a 0.11 or a 0.12. However, there's ways to fight those as well, and there's certain, now they call them uncertainty measurements or measurement of uncertainty, but if you get a 0.11 BAC, you can walk that down to a 0.079 based on different margins of error. 0.02 agreement, 0.01 reference solution, margin of error, and then Goldberg truncation of the third digit, 0.09 brings it down. Anyway, it's probably too much information on that. Any more questions? How do you handle it if an officer asks the level of intoxication from 0 to 10? That's a really good question. So, thank you, James, for acknowledging that was a great question. So officers are doing this thing now where they pull you over and they say, okay, you know, they find out you've been drinking. They're already going to arrest you if they smell the odor of alcohol. Of 0 to 10. And some of them, they phrase it differently, like 10 being the most intoxicated you've ever been, or some of them say 10 being like really intoxicated, blacked out or something, and 0 being totally sober. Where would you rate yourself? I hate this question when they ask that, because clients feel like that they should be truthful, and they do. I mean, it's good to be truthful. They will say like a 3. Sometimes they say a 5. I've had a client say like a 6 or 7, and then I'm rating them on that scale. But here's the way that we look at that. Okay, what does that really mean? That, and use it and frame it with the jury, and try to cover it before the state throws it out there and before they hear it on video. So let's just use the case we had. My client, I asked him this in trial. The cop did not. I said on a scale of 0 to 10, 10 being totally sober, and 0 being totally sober and 10 being completely intoxicated, where would you rate yourself? And he said, we talked about this, and he told me a 1. I said, okay, why not a 0? And he said, well, because I had 3 drinks. So 0 means to me that it's no drinking. Did you feel this? When you drink, you feel the effects of alcohol. Were you intoxicated? No, I was not intoxicated. So a 1 is a fine answer. He gets on the stand, though, and he says, oh, a 1 or a 2? It's like, you should have stuck with the 1 like we talked about. But I said, okay, what does that mean? And he said, well, I did have 3 drinks, and I felt the effects of the alcohol. I was not intoxicated at all, and he was solid on that the whole time. At all. So there was another case where a person answered a 3 or a 4, and the way we dealt that was in voir dire. And I asked people, raise your hand if you. I said, if you've never had any alcohol, and there's always a couple people, but for those of them that drink, 1 drink, do you feel the effects of that? And people say yes. That's why people drink alcohol. And what about after 2 drinks? Do you feel the effects of that? Sure. After 2 drinks, we feel the effects of that. Has anybody had 2 or 3 drinks at a restaurant or bar? And you feel the effects of that, right? Yes. But when you drove, and of course they all say absolutely not. And on a scale of 0 to 10, and you said a 3, do you think that's admitting you're intoxicated, or is it reasonable? It's an admission of, I feel the effects of the alcohol, but I'm not saying that I'm intoxicated. So that's one way to handle that question. That question of anybody, you should, it's probably best just to say something like a 1. I have had something to drink, so I'm not going to say a 0, but I'm not intoxicated, and I'll say 1 because I'm not intoxicated. Is breath better than blood? Some people say that it's easier to defend a breath test case, and that probably is true, because juries show up. The average juror now has heard for years in the paper and on TV that the breath testing machines are not reliable. Would you mind grabbing a plug, because this is about to go out? There's one in my room. Here you go. Hope we don't lose. Yeah, hurry. So probably most attorneys would prefer to defend a breath test case, because most jurors have heard that breath is very unreliable, and the breath test machine can go wrong. The maintenance and calibration isn't always there. There's things that can skew a breath test result to create a false positive. No, it's not true that if you, well, it might be true. If you put a coin in your mouth and blow, it'll be higher, but there's supposed to be a 15-minute observation period where the officers watch you to make sure that you haven't regurgitated, vomited, coughed, put anything in your mouth. I had a client one time that had a pouch of tobacco in his mouth when he blew, and he swallowed, he didn't spit, so that's how the officer didn't know he had it in there. So when we went to trial on it, I had him put a pouch of tobacco in his mouth while he was on the stand, and then asked the judge to suppress the breath test because he had something in his mouth. And to prove it, I said, Judge, he's had it in his mouth the whole time while he's been on the stand right now. I mean no disrespect to the court, but I just wanted to prove the point that he can have it in his mouth and not spit for a long time. And the officer never checked in his mouth, and they believed us, and we got that suppressed. So blood, we're starting to turn the corner on blood. Most jurors think that blood is the gold standard. It is not the gold standard. As a matter of fact, the truth is blood is much less reliable than a breath test. Much less. And the reason is because there's so much more room for human error to come into play. There are 5 to 10 people involved in a blood test before it ever gets tested. On a breath test, it's one officer, push the button, have them blow. That's it. You would be surprised to know all the problems that there can be with blood testing, but it is not reliable at all. And it's very difficult to produce a valid blood test. The machine will test it accurately, unless there's problems with that machine. We found that out as well too. Calibration problems, operator problems, putting the vials in the wrong spot on the carousel, mislabeling them. We've had expired vials. Gas chromatography is a good scientific testing method, but the problem with blood is all of the people involved before it gets to the machine. So we're waiting on Justin to go get us a plug, so hopefully our computer won't die. Shelly, is there anybody that has joined this chat session at all? Oh, there. Okay. Well.
Yeah, we do.
Another question.
People.
You handle. Okay. How do you handle defending clients who have done a poor job on the standardized field sobriety test? That's a good question. Field sobriety test, because if you have the odor of alcohol on your breath and you're pulled over, they've already made up your mind and they're going to arrest you and take you to jail. So then you should not perform those balancing tests. We call them roadside gymnastics, or somebody calls them monkey tests. They're not a good test of what is normal mental and physical faculties. Not having the normal use of your mental or physical faculties by the introduction of alcohol driving. So I cross-examine these officers all the time about, how do you normally stand? Do you stand with your feet together, heels together, hands down by your side? Or do you stand with your feet apart, about shoulders width? And they always admit, yeah, no, it's harder to balance when you stand with your feet together, hands down by your side. That's not normal. Well, do you walk a straight line, touching heel to toe, 9 steps down, turning using a series of small steps, counting side, looking at your feet? Do you do that normally? No. Do you think other people practice that normally? No. Okay. Well, why is that a good test for? Why is that a good test for what the person's normal mental or physical faculties are? And most jurors will agree that it's not. So I'm not so concerned about. Do you balance on one leg with your hands down by your side, looking at your foot, holding it 6 inches off the ground, counting to 30 by 1,000? Do you practice that? Is that a really good test of what a person's normal physical or mental faculties are? I don't think so. And I think it is designed to make you have trouble. So if you do those tests, it doesn't matter that much if the officer says that you failed them. On the one-leg stand, there's 4 clues: swaying, hopping, using arms, or touching foot. If you do 2 of those things wrong, if you put your foot down one time, that's halfway to failing. And they don't even tell you, don't put your foot down. They say, They say if you put your foot down, just pick it up and keep on going. So it's like a teacher. When we board dire on that, we ask teachers, do you think it would be fair to test your kids on something, but you don't tell them what you're testing them on? And the officers are essentially testing people on things that they're not telling them what they're looking for. They don't say, if you put your foot down, I'm going to count that as a sign of intoxication. They just say, if you put your foot down, pick it up and keep going. So they make them feel like it's okay to put your foot down. Oh, yeah. I don't know if I have a plug around here.
Your room's not working. You're told you
can find a plug.
There's a plug right there, but
relocate. Did you grab that for me?
Yeah.
So I don't really. It doesn't bother me that much if people fail the field sobriety test, because you're almost always going to fail the field sobriety test according to the officer's criteria. What's more important is just how you balance. If your overall balance looks good, then that's what the jury's going to be most concerned with. Because they can tell what an intoxicated person looks like and what non-intoxicated person looks like. So it's very difficult. Even if you hadn't had anything to drink, you're most likely going to fail the field sobriety test. If you think you've had that much to drink where you're going to totally fail them, don't take the sobriety test. Just politely refuse them. Don't tell the officer any, don't be mean, don't be rude, don't use cuss words in refusing. Just say, I'm sorry, I've been advised to refuse these tests. I had one client that I successfully defended on 3 DWIs, and he refused the balancing tests on all 3 occasions. The first time he just got lucky that he knew what to do on his own. Then after that, I told him, I said, you know, it's probably not a good idea to do those because they're very difficult to do. And well, after the third, well, we're not going to dismiss the first one because he refused everything. And I said, I get that. They said, we don't want to send a message that if you refuse everything, you get your DWI dismissed. I said, I understand that. So about a week before trial, they did dismiss the case. And then 6 months later, he got arrested for another DWI. And he said, I'm going to refuse everything again. And they said, well, we're never going to dismiss that case. I said, I get that. He actually saw the same officer that arrested him the first time in the jail, and he said, I beat you once, I'll beat you again, which was not an ideal thing to say as a defense attorney. Well, on the day of trial, they dismissed that one as well because he refused everything. And then 9 months later, he got arrested again, refused all sobriety tests again. They did not dismiss that case. We went to trial on it, and they did not have enough evidence because he didn't do the sobriety test, and we won, and we got a not guilty verdict. So I had a serious talk with my client after that, and I said, we need to talk. You need to be careful. I think you have a problem. And he said, well, that's okay. I moved from the bar, so I'm just going to be walking from now on. So that was the solution. Okay. Let's see. Justin asked, it sounds like a good attorney should try to appeal to each juror's common sense. Is that correct, or am I oversimplifying? I think that is a great strategy, and I'm not sure what regard, but if it's regarding the field sobriety test on the disconnect, right? Okay. Yeah, it makes more common sense. It's like, just like the thermometer analogy. Does this make sense that this person looks this good on video and is really a 0.21 and had 18 beers? Use your common sense. That's what the state says a lot. They say use your common sense in convicting, and I always object because they say that beyond a reasonable doubt is just use your common sense, and that's not what beyond a reasonable doubt is. Of course, you can use your common sense, but when you're looking at the disconnect defense, it doesn't make sense, and it's not common sense for a person to pass the field sobriety test, look solid, and just be so complete, according to the lab analysts, be completely intoxicated to the point where they would be passed out. And that's where we say, look at the big picture, use your common sense, something's not right. We weren't there testing the blood. We don't know exactly what the problem is, and they probably won't admit that there is a problem, but we know there's a problem. And use your common sense. This doesn't match up. That's a disconnect.
Can I ask a follow-up question?
We got a live follow-up question, yeah.
So what I would wonder is whether or not, I know that jurors are instructed that their expertise or their own experiences into a jury room, but in their common sense into the or otherwise is it objectionable if someone argues that?
That's a good question. I don't think it's objectionable to tell the jurors they can bring their common sense into the deliberation room. It's just when the state crosses the line and tries to define what beyond a reasonable doubt means,
right.
They say we can't define it, just use your common sense.
Okay.
And that's where it's objectionable, because beyond a reasonable doubt isn't just use your common sense. There's no definition for it. Texas has not tried to define what beyond a reasonable doubt is. So when the state says all common sense, that's defining beyond a reasonable doubt, and we object to that, and that's always sustained. Okay. As a defense attorney, if the state's telling the jury it's okay to have your common sense, and then you're the defense attorney and you stand up and you say don't use your common sense, that kind of looks pretty silly, and I would never say that. So there's different strategies for different types of cases. We got 15 minutes left on this one. Maybe there's no more questions. This might be a good time to sign off, or so we want to try to encourage everybody to submit your questions, please. You got to go to Google Plus and the Hangouts, and any cases you have. If you're an attorney handling a DWI and you have a specific question about your case, come here and let's chat about it. I'd be happy to tell you about my past cases and how to handle certain issues in your case. I want to help educate. If you are a person charged with DWI, questions, I'll be happy to give your questions, what to do. I know it's a scary process or a scary procedure. You're not sure about what lies ahead. I can tell you most of the time it's not the end of the world. Most of the time we're successful and we're able to make these go away, even if there's very difficult facts. So thank you for tuning in today. It's Friday, March 27th, and we're doing our first one live from Bourbon Street, signing today at 2 p.m. Tyler Flood, Houston, Texas, DWI attorney.